Let's talk about Amber Heard's appeal brief. Fool me once here, driving instructor of the world. This first video is going to be an overview of all of the arguments in Amber's brief. It's also going to talk about a few adjacent issues. For example, Amber's brief was postponed. She was supposed to file this on November 3rd. On November 18th, she asked for an extension. And even though it was objected to because it shouldn't have been allowed, the appellate court granted her the extension. Now, we find out the reason for that extension because the day before Amber's brief gets filed, two amicus briefs, two friends of the court briefs get filed. It's a nice way to subvert the word count because they also are done by attorneys and they make legal arguments in those friend briefs. There's a third one that was filed a long time ago that's a little weird. We'll talk about too, not from an attorney. Now, of course, I'm not the appellate court. I don't know how they're going to decide, but I will present to you Amber's arguments and then some of the facts of the case that the appellate court has access to. The appeals court, you have to understand, always assumes that the judge and the jury, they are the ones that heard the case. They got the facts of the case right. What they're looking at is, did the judge get the law right? Are the issues that were admissible correct? Were the ones that kept out also correct? And would they have, if changed up, if the law wasn't followed, altered the verdict in any way? Okay, the first main argument in Amber's brief is for the location where the trial was held. Virginia was not the right forum. It's called non-convenience forum. It should have been held somewhere else, and they say that Amber didn't live in Virginia. She hadn't set foot in Virginia before this, that she remembers. It was edited in New York by the ACLU, was written by her in California. It shouldn't have been in Virginia at all. Only the piece uploaded to the servers in Virginia happened. Also, because these issues were already considered in a case in the UK, they should never have been allowed to be heard here in the US. 3, the statements that were expressed in the op-ed were Amber's opinion only, and you can't take action against someone's opinion. Those statements, they then go on to say, weren't defaming in any way, or they weren't defamation by implication. They did not specify Johnny specifically. Johnny's team didn't prove actual malice, and the jury should not have ruled on malice because they didn't even understand malice at all. That's right, they say the jury didn't understand. They're mad about bringing up Pledge versus Donate. They're mad about bringing up the SeaTac case where Amber was arrested. Then they say Amber didn't publish this, she tweeted it.